and just government of men. We beseech thee to behold with thy abundant favor us thy servants whom thou hast been pleased to call to the performance of important trusts in this land. Let thy blessing descend upon us here in this house assembled. Grant us that we may treat and consider all matters that shall come under our deliberation in so just and faithful a manner, to promote thy honor and glory, to advance the peace, prosperity, and welfare of this country, and of those whose interests thou hast committed to our charge. Amen. Good morning. Please be seated. Thank you. Thank you. Yes, go ahead.
Correction and approval of record of votes and proceedings of the National Assembly sitting of Thursday, 25th June 2020.
Thank you very much. Good morning, honorable members. Good morning, honorable AG and staff, members of the press. Honorable members, the record of votes and proceedings of the National Assembly sitting of Thursday, the 25th of June, 2020 is before us for correction and approval. Can any honorable member please move that the said records be considered and approved? Yes, who is?
Thank you, Honorable. I rise to move that the record of votes and proceedings of the National Assembly sitting of Thursday, 25th June 2020 be corrected and approved.
Thank you. Seconder, yes, Jara Central.
Kioma, seconded.
Thank you very much. It has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Thursday, the 25th of June, 2020 be approved. Any issues or observations from honorable members? We start with page 1. Any corrections? Yes. Loa Nyomi, page 1.
Thank you very much, Madam Speaker. I am not in line with what the Assembly has. I have Wednesday, 24th June, number 2, order paper. Corrections and approvals of records of votes and proceedings of the National Assembly sitting of Wednesday, 24th June. That's what I have. That's why I said I am not in line with the Assembly. 24th June. Thank you, Madam.
Are you reading the order paper? The order paper. Yes, you are reading the order paper. That's on page 1. Good, thank you. Thank you. Any more on page 1? Page 2. Can we confirm that the names are correct? The attendance, yes, Sabah Sanjal.
Thank you, Madam Speaker. Page 2. I stand to be corrected. Number 40, Alaji SB Silla and Honorable Asan Ture were absent. 40 and 42.
I did not get that, but I suppose the table office has captured it. Thank you. Any more on 2, page 2? No? Page 3? Continuation of the attendance, yes, Vasanja.
Yes, page 3. Honorable Matar Jang, 48, was not here, and he's captured under the present list. On Thursday, yes. Omar Dabo, 53, and the last one, Alaji Sankung Jame, 55.
I think they were here. Yes. Continuation of 3.
Thank you very much. Page 4, number 3, laying of papers and reports. Paragraph 3. Second line, training and ICT for further scrutiny and report back to plenary. Back to plenary is missing. Thank you.
We'll complete the sentence. Yes, Wooly is?
Thank you. If you go question put and agree to, immediately before that, the line, the word benefit, the spelling of benefit, according to the member from benefit.
Get you, neither did the table office. Can you repeat?
Now I'm saying, according to the member for Fonyi benefit, the spelling of benefit is B-E-R-E-F-E-T, not B-R-E. Huh?
In that case, the spelling on the constituency tag needs to be corrected. Thank you. Table office, please take note. Thank you. Page 5. Yes, Wooly is?
Page 5, among the members that took the floor and spoke on the report includes Honorable Swaibu Ture, and the name is missing.
Thank you. Any more? Page 5, yes, Passe.
For consistency purpose, at this juncture, the Honorable Speaker called on the Vice Chairperson mover to respond to issues raised in the reports and wind up the debates. And wind up the debate is missing. And if you go to the second line, the Honorable Vice Chairperson of the committee responded to issues raised in the report and wound up the debates. That also is missing. Thank you.
Six. Page 6. 7. Yes, Passe. Page 7.
Madam Speaker, the same concern on paragraph 1 and paragraph 2. Thank you.
Yes, Gimara.
I'm sorry for taking us back, but when you go to page 6, where Honorable Halifa Sallah is, I think Serekunda, the way this spell is wrong. I said on the Honorable Salah's name, where the constituency, the way they spell the constituency is wrong. Page 6. Yeah.
Page 8, honorable members. No. Page 9. Page 9. Page 10. I don't take it that we are all satisfied with the records. Thank you. It has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Thursday, the 25th of June, 2020, be approved with amendments. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. Clerk, can we proceed with the next item on the order paper? Thank you.
Thank you. Bills. As per Standing Order 72, consideration stage of the following bill. Constitution Amendment Bill 2019 by the Honorable Attorney General and Minister for Justice.
Thank you very much. Yes, honorable members will recall that the Standing Committee on Human Rights and Constitutional Matters reported on the bills committed to it. That is the Constitution Amendment Bill 2019 and the National Human Rights Commission Amendment Bill 2019. The reports of the committee were adopted, and accordingly the consideration stage of the two bills is scheduled for today. Now, during the consideration stage, members will have the opportunity to give detailed consideration and scrutiny to every clause and schedule contained in the bills. This stage, that is the consideration stage, also provides the first opportunity for amendments to the bill to be debated and voted on. I will now therefore resolve the Assembly into Committee of the Whole Assembly to give consideration to the two bills, that is the Constitution Amendment Bill 2019 and the National Human Rights Commission Amendment Bill 2020. The Assembly now resolves into Committee of the Whole Assembly. Thank you.
Very difficult to go into your archive. Huh? To check all these things.
Sorry. Honorable members, can we have one meeting, please? Please, 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 please. Consideration stage, Committee of the Whole Assembly. The Assembly now moves into Committee of the Whole Assembly to consider the Constitution Amendment Bill clause by clause. We will be missing the member for Woolly West. We will also be guided by the committee's report on the bill and clause 72 of the standing orders during the consideration stage. There appears to be some background conversation. Can we be put in the picture so that we can sort out if there are any problems, issues? Sorry, I was made to understand that most of the time, in fact, in all cases, all documents are put in the pigeonholes. So I think it's also important that we ensure that we check our pigeonholes in the mornings and in the evenings, every day that we are in the assembly, especially during session. Otherwise, it will cost the assembly a lot if we on time also. It will not save our time if we have to reprint again. You have, all of you are okay. Thank you very much. Hello?
Constitution Amendment Bill
We start
2019.
With the Constitution Amendment. Yes. Constitution Amendment Bill 2019. Can you start?
Clause 1, short title.
It is proposed that Clause 1, short title, stands part of the bill. Those in favor, please say aye. Please, Jumara. Those not in favor, please say no. For some reason, I'm not seeing you, but this is the first time it has happened. I don't know why.
Yeah, it's because of this.
It's because of the box. So next time you need to raise your tag a little bit.
Exactly.
Yes?
Yeah, Honorable Chair, the committee informed the House that there will be amendments from the mover. Has that actually happened, or does the mover have something to say regarding, because that's the key element of this amendment?
Yes, Honorable Speaker,
I think I got your point. Yes. So we'll listen to the Honorable Attorney General to see whether that bit has been reflected in the reprinted version. Honorable.
Madam Speaker, sorry, my attention was on the report that we just received. Is there a proposal to amend the proposed amendment by the committee? Well, Madam Speaker, to that proposal, I will say the amendment that was tabled by myself was after consultation with the Honorable Chief Justice, and of course other members of the judiciary, and we are fine with the proposed amendment by the state. We do not want to complicate matters. I haven't had the opportunity to look in detail at the proposal from the committee, but it appears to me that they're slightly different from the amendments that we are proposing. And in the abundance of caution, having consulted with the Honorable Chief Justice and the judiciary, and we agreed on the text that is being proposed for amendment, and we would like to retain that proposal for simplicity, because the idea is essentially to remove this imbalance, as we said, between those in private legal practice and those serving the judiciary. You can have a magistrate who's spent 10 years on the bench, but because they haven't been master or a principal magistrate, they can't be elevated, and we want to remove that. And the proposal we are introducing here makes it very easy. If you're called and have 5 years experience, the competence, the qualifications will be a matter that the Judicial Service Commission will look at as part of their scrutiny of candidates for elevation or appointment. But that's a responsibility that is traditionally with the Judicial Service Commission. That will not change. But just to conclude that this has been after consultation with the Honorable Chief Justice, and we do not intend to depart from this proposal. Respectfully, Honorable Speaker.
Honorable members and honorable member for Serekunda in particular, why don't we go with the procedure until we get to that substantive amendment, and then we'll hear views from it, from honorable members. Otherwise, we'll be jumping from one thing to the other. But I have seen your point, and I have also heard him, and I have seen the proposed amendment of the committee, whose report has been adopted by the National Assembly. But just for purposes of sequence of events, let's start with clause 1. If we feel that there is still need for further amendment, you can still go and tidy them, the house, put their house in. Is it? Yeah, before the third reading. Yes, clause 1, stand part of the bill. Those in favor, please say aye. Aye. Those not in favor, please say no. So the ayes have it.
Clause 2.
Clause 1 now stand part of the bill.
Clause 2, amendment of the Constitution.
It is proposed that clause 2, amendment of the Constitution, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So clause 2, amendment of the Constitution, now stand part of the bill. Clerk, proceed.
Clause 3, amendment of section 139.
Yeah, that's the issue. Thank you. Clause 3, amendment of section 139, it is proposed that the clause stands part of the bill. Those in favor? Okay, before that, yes, Serekunda, you can now make your...
Yes. Honorable Chair, the committee gave a report, and we posed the question, had there been enough consultation with the original mover of the motion? And apparently we received something in the affirmative. But apparently we are beginning to see that that is not really the state of play. And apparently it does not even appear that the original mover has been favored with the actual agreed amendment terms by the Assembly. Wouldn't it be prudent to have some little consultation so that he sees what is actually being proposed, which may be very much in line with what they had actually moved before the National Assembly? Shouldn't that be the trend now? Is he fully aware of what the Assembly resolved? So could that not be put so that he gets the the information correctly.
We deal with institutions and not individuals, but I can assure you that Mr. I don't know his name, the principal, what do you call him? The Parliamentary Council, yes, was with the committee throughout. I stand to be corrected, but I would rather the chair of the committee explain to this whole House what actually transpired. Now, whether he relayed the information to his superiors, I may not be in a position, but I would have expected that that would have been done. Because I am sure that if we had probably seen this earlier on, we would have. Yes, but before I allow the chair of the committee, I think the Honorable Attorney General wants to come in.
Thank you, Honorable Speaker. If I could just clarify that the Speaker had indeed reached out to me previously on this and wanted us to send a representative to the discussions about this proposal. I am only for the first time seeing it in writing, but my Solicitor General is informing me now that the Parliamentary Council was engaged in it, and we had actually consulted the Honorable Chief Justice on this matter. I myself did so, and we wrote back to the National Assembly to maintain the position. And if perhaps I can be of little help, just looking at the drafting, I think it may create confusion, respectfully, because I'm just looking at it now, and at the top of my head, it says held office as a magistrate. You can be qualified. Now, the difficulty is that sometimes we do have lay magistrates. And if you have a lay magistrate who's held office for not less than 5 years, then technically, in principle, based on this draft, they may be qualified as a judge of the High Court. Whereas the proposal that came from the CJ and us is very clear in terms of the qualification. So if there is a magistrate who is also qualified as a legal practitioner, then they are also captured in this. Whereas in this interpretation, based on these wordings, there may be room for different interpretations. And that is also what we want to try to avoid by providing this simple and straightforward proposal. I hope that helps.
Yes, Honorable, if you see the draft, it's not just magistrate, it's principal magistrate. It's principal magistrate. If we held the position of principal magistrate or master, those are the two, yes.
I don't think a lay magistrate would rise to the position of principal. Sorry. Just, honorable members, can you just have a look at your report? The report, the one we the one that was adopted. Just the proposal. Chair, can you read the proposed amendment by the committee? It's on page 3. Before I allow the Honorable Attorney General, he appears to have the wrong copy. I want to make sure that we are also dealing with the correct copy.
Does the committee recommend this draft? A person shall be qualified to be appointed as a judge of a high court if he or she holds or has held office as a magistrate. Okay.
No,
for not less than.
You still have the as a principal magistrate is what I have.
Okay.
That was the previous one. Can I read what
No, Honorable, there is a little change. If you go to page where you have observation,
Yes.
and it says section 139.4 of the 1997 Constitution reads, that's why you have principal magistrate. Yes, I think our recommendation, even though our intention is principal magistrate, but what we have there is magistrate in our recommendation. So I think he is right when he mentioned magistrate. I read the whole thing. Do we read the whole thing and see? A person shall be qualified to be appointed as a judge of a high court if he or she holds or has held office as a magistrate for not less than 5 years, or if he or she has practiced as a legal practitioner before a court having unlimited jurisdiction in civil and criminal matters in a common law country for not less than 5 years. That's why we put experience in there.
I remember we really debated on the issue of experience as well and practice, somebody who has practiced for 5 years. Because I think what we were trying to avoid at the level of the committee was for somebody qualifying as a lawyer, just a corporate lawyer, sitting out there without necessarily having the experience of legal practice to be promoted to the bench. And I think that was why we captured the issue of experience as a legal practitioner as well.
What I could remember is that experience was missing in their draft. And we put in experience there. And they accepted that that was an omission on their part. That's what I could remember. Yeah.
Also now that we are at the consideration stage, consider the issue that the Honorable Attorney General has raised. If you, they're trying to avoid a lay magistrate without necessarily, yes. So I don't know how it can be reframed to capture all the elements. Yes, Honorable Member for Serekunda.
I think they are guiding us now in the whole drafting process. What is very clear, Honorable Chair, is number one, they were trying to cure the problem of simply excluding qualified people because they are not principal magistrate or master from occupying the bench, whilst other legal practitioners could occupy the bench, which means that you are discriminating a whole group of people from occupying the bench. So that's what they were trying to cure. Now, what they have given us is people who are qualified, excluding the other elements. So the qualification is the focus, and he's saying that is still their focus. But our committee said that qualification alone, somebody who is just qualified, is not sufficient to also provide the experience necessary to occupy the bench. I believe that the Honorable Attorney General should help us because we are working on conscience, we are working on curing a problem, and we should not cure a problem only to create another problem that somebody who feels qualified academically. So what does qualification means?
May I just assist? I think the Honorable Member for Serekunda captures it very, very accurately. Your sum up is to the point. Perhaps what I can say by way of assistance is that the Judicial Service Commission acts as a filter for exactly that purpose, to look at the relevant experience and background of any particular individual who is proposed for appointment or elevation to the bench, and to determine whether, on the basis of that background, that assessment, the person may or may not be appointed. So that is the point of the Judicial Service Commission, by the way, to make sure that they look at the fitness of a person who's been proposed. But if you want to build in the issue of experience into the act itself, it may be subject to different interpretations, and we also want to avoid that. So I think the best way forward, as far as I can see, is to adopt the amendments that we have proposed and to defer the issue of experience and other qualifications to the competence of the Judicial Service Commission, which should be doing that in any event. That is why they are in existence. Thank you.
Yeah, thank you very much, Honourable Speaker, for giving me the floor. What I want the Honourable Minister to help us, the committee proposal to put in at least 5 years experience, that will serve as a legal backup, per se, to guide the Commission, the Judicial Commission, that is part of the constitutional recommendation of constitutional language, that we factor in experience. So once they have that thing captured there, it will give them that form of legal backing, sort of, that experience is being said in the Constitution, and it should dictate the process. So if we put in place experience there, and then it will also trying to unify the entire process, that we have got a legal document that talks about experience. So basically, it will assist them in the entire scrutiny as well, but not to leave it ideal like that and allow them to use their conscience or their discretion, but it has to be backed with something written. Thank you.
Yeah, honourable members, can we just look at another scenario? Somebody is qualified as a legal practitioner for 5 years, but has never practiced in the courts, never. But you've been qualified maybe for 10 years, even as a legal practitioner, but you've never practiced. As I said the last time, you're a corporate lawyer, you're at the banks or anything. Now, I think that's one of the issues we were trying to avoid, to capture the issue of experience, because you're dealing with procedures at the high bench there. Even as a magistrate, you deal with procedures, so if you've never practiced as a lawyer, but you have the requisite qualification, can't we also see how we can capture the element of experience in it? Thank you. Nyamina is, thank you.
Yes, thank you very much, Honorable Speaker. Like you said, the committee is somehow confusing because the committee is not claiming authority in this, and we were not doing this alone. The authorities responsible were invited, and upon discussion, they tend to agree. They agreed to what actually was discussed. That is why we came up with the proposal. And it means then it is not just the committee who was dealing with the subject, but the authorities were invited, and upon discussion, they agreed, they deemed it fit that it is necessary for it to be incorporated in the bill. That is why it was adequately captured in that bill. So I don't know if people from different, maybe, or the same authority are speaking differently, so I will find it so confusing. But nonetheless, they are the experts, and they know better. But this is what the authorities responsible did indicate to the committee. That is why we have to come up with this. Thank you.
Yes, I just want to ask, what is the problem with the proposal from the AG, from the mover of the motion? What is the problem with it?
Thank you, Madam Chair. I think going back to the recommendations of the report, we specifically pointed on the lack of clarity and the deviation from international standards, and that was why we emphasized on not only the qualifications, but on the 5-year experience. I think we should stick to that and make sure that it reflects. Because when we say experience to the bench, of course, we do not mean selling at the market, or we do not mean working at the bank. We mean experience specific to that job. It is left to the Supreme Court to do the interpretation, but a layperson would take it as experience specific to what we are talking about. So I think it is necessary for it to be reflected in the bill, not only for the qualifications per se, but for the 5-year experience, because it was recommended and it was adopted at this plenary. So I think we should maintain that recommendation.
In fact, a reference was made to the provisions in the constitutions of Zimbabwe and Kenya. Yes, Badibu, Central Badibu.
Thank you, Honorable Speaker. I think, Honorable Speaker, the issue that has been raised by members in the response of the AG, I believe in reference to Section 147 of the Constitution, where you have the Judicial Service Commission, other functions of the Commission, subsection Clause B, to make recommendation as to the terms and conditions of the services of judges and other judicial officers and staff of the courts. I think this is well explained. I think that one can guarantee that in the selection, experience and other issues will be considered. So I don't think we can. For me, I think we are comfortable with this. And when it comes to the this clause of the Constitution, can cater for that. So with this recommendation, I think we can move.
Thank you. Yes, Serekunda.
Honorable Speaker, we must bear in mind that we are the lawmakers. They are guiding us, but we are the lawmakers, and we should be properly guided. And we cannot be properly guided unless we raise questions and then satisfy ourselves that the answers satisfy that principle of being guided by conscience. Honorable Speaker, again, we'll just mention this for the Honorable Attorney General to focus on and guide us. The amendment is a person shall be qualified to be appointed as judge of the High Court if he or she has qualified to practice. Qualified to practice. Now, if you look at the original provision, it says that he or she has practiced as a legal practitioner. Has practiced. That is, if you go to 139.4 of the what is in the Constitution that we seek to amend. What we seek to amend states in this element of practice that if he or she has practiced as a legal practitioner. And what I thought they were trying to cure is the first leg, which says that if he has held an office as a principal magistrate or master, meaning that this is an administrative post. And how many people will serve for decades as magistrates, qualified people, but will not reach the office of master and principal magistrate? So it was very clear that what they were trying to cure is spot on. Now, they have tried to cure it by giving us this. And what they have given us, of course, it cures it. It means that if you are master, not master, magistrate, whatever, but you are qualified, then you are considered. But then our committee says, well, it's not sufficient just to be qualified, but it's somebody who has practiced. I think this is the element. So if this does not make sense, well, help us to show that, well, this does not make sense. But it seems to us when our committee reported that just has qualified, meaning the person is qualified to practice. The person is not necessarily somebody who has practiced. And they felt that, well, that person really should not be competent to hold that office. Well, this is the debate. So it's not a very irrelevant debate. I think it's relevant in lawmaking.
Thank you very much, Honorable Speaker. And if you look at the report of the committee, they did really, I have to thank them so much. They really endeavored to look at best practice elsewhere. And there, they spot the Kenya, which says 10 years of experience. This is captured in their constitution. And if you go also to Zimbabwe, in fact, it's 7 years. So I think the entire membership of this August Assembly will stand resolutely behind them to push him for the 5 years experience to be captured. Thank you.
Yes, Honorable Speaker, I don't know, the Attorney General was talking about the Judicial Service Commission responsible of experience. So, but if you look at 139.4, it has always been mentioned in the opinion of the Judicial Service Commission. If the person has this experience, they can appoint. So our concern is to capture experience. We don't want to just leave it blank like that. We want to ensure that experience counts. Whether if that is in practice, that's what they are doing, then we are fine, but it needs to be captured. That is our concern. So how we can do that? You understand?
Do we vote on the proposed amendment? Oh, sorry. Honorable.
Yes, just maybe one last time, Honorable Speaker, and thank you for your indulgence. I think all the members are right. I mean, it needs to be clear. You want to, the qualification is okay. I think we're all agreed on that. Is whether what is contained in the proposed amendment caters for the experience part of it. I think that is the concern. And I have said that that concern is addressed by the powers that the Judicial Service Commission has in making recommendations for appointment, because that is part of their functions. Their function is to look at different candidates and then decide on the basis of the assessment of a number of factors as to whether candidate A should be recommended or candidate B should not be recommended, and the basis for recommending or not recommending. And I think we have to trust in the Judicial Service Commission, which is headed by the Honorable Chief Justice. The difference, the problem, the challenge we have here is that Section 139 of the Constitution, as the Honorable Member Serekunda said under subsection 4, there are two legs. The second leg is what we're trying to, sorry, the first leg is what we're trying to address. And the reason why Section 139 is drafted in this way is because you can categorize magistrates as legal practitioners. You see, that's the problem. That's why Section 139 deliberately caters for the magistrates class and then also for the legal practitioners class. But here we are removing these two categories. We want to have just one category where we say, if you're qualified, whether you are a magistrate or whether you're a principal magistrate or a master or not, so long as you're qualified to practice as a legal practitioner, you are eligible. It doesn't mean you will be appointed. Eligibility is one thing, appointment is another thing. So it means you can be considered, but at the discretion of the Judicial Service Commission, based on consideration of your background and experience, they may recommend or not recommend you. And I think that is the function of the Judicial Service Commission, to act as a filter in this process as well. Thank you.
Yeah, thank you very much.
Fuladu has raised a question. You asked a question. What was the...
Exactly. No, I think I'm starting to understand the whole rationale behind this amendment is because I think the Honorable Attorney General did mention in his, when he was tabling the motion, that we have an issue of judges in this country, in a sense, trying to work with of cases that we have. So they want to elevate so allow that privilege, and to the opinion of the JSC, that's the Judicial Service Commission, to look who is eligible, who should be appointed, but who should not be appointed. But at least we are addressing one issue, is to make many Gambians available, eligible to be appointed as judges. And therefore, we don't have these problems now in the courts that we have now.
We should just bear in mind, Madam Chair, that it is not an alternate. It is both. It is not either or. It is the qualifications plus the 5-year experience. So I think that should be emphasized. That is very important. That is what I wanted to make an emphasis on that. It shouldn't be left on the commission to just, it should be emphasized.
Yes, Honorable Speaker, I think the Judicial Service Commission, we are trying to give guides. In terms of scrutiny, of course, we are not debating whether we trust them or not. But in terms of scrutiny, we are trying to guide them that this is the period that one might have in order for him or her to be qualified. And the period that the committee is recommending in consultation with the authorities responsible is 5 years. And there, if they are doing their scrutiny, they will bear in mind that the experience that one needs to take into account is 5 years. That is what the committee is emphasizing. And I will repeat by saying the committee was not doing this alone. The authorities were consulted and they were satisfied with this.
Madam Speaker.
Let me put it this way, that their amendment is saying that the person shall be qualified to be appointed as a judge of the High Court if he or she has qualified to practice as a legal practitioner. That's the qualification. And what we are saying, could it also include either has qualified to practice as a legal practitioner, and we are saying if he has qualified and is sitting as a magistrate or has, here it is saying has practice, is either the bench or has practiced as a legal practitioner. How do we coin this, Honorable Attorney General, where the person is qualified but has been a magistrate or has practiced, as a legal practitioner? Is there anything we can do? Because this is the mind of the committee, and help us to know that we were trying to do what we are supposed to do, to cure something. We have cured what you said, the principal magistrates and masters having monopoly of being appointed, even though others may have had the experience. Okay, that you've cured. But what is being said is that we've created another illness where we're just dealing with people who are qualified and may not have sat in the bench or may not have even cared, to really practice. So how do we handle that? That's what we are trying to cure.
Sir, Honorable Attorney General has a proposal.
I'm here.
Yes, thank you.
Clerk.
Speaker. I think what the committee was concerned
Clerk, can you help me, please?
is to
I'm calling the attention of
include
the
the
Speaker.
experience.
Yes, yes, I'm listening to my talk all along. Honorable
Sorry,
Speaker.
my guides, you understand that they should have drawn my attention.
That's why I'm calling the attention.
Because I did allow few from here.
Just call your attention rather than the amendment.
Clerk, please, yes, can you push your chair? Yes, good. Yeah, before we allow the Attorney General, can we hear you then?
Yeah, thank you very much, Honorable Chair. I do agree with the committee's recommendation based on the fact that a High Court judge is not a, small position, a low position. A High Court judge, not only you have your master's or your PhD in law, but at least I think you should be somebody who has served as a magistrate to get experience, because you're going to sit over there as a High Court judge. If you are not acquainted with the proceedings, the procedure of the understand, how to deal with the cases, how to administer cases is going to be a problem. This House must be very careful. And I've said it here last week, when we are dealing with the issue of Council of Members on the recommendation of Njai and disaster experience. People ignore it. Njai had a very important, a very long experience. That thing has been ignored. But today I still maintain the experience. Let's let this House always make sure that whatever we adopt, it has to be in line. We all know since inception in the civil service, first, before they pick, when people have the same equal qualification, what they ask for is the experience. This honorable House trying to play. Every now and then we are playing with the public is looking at us. Very inconsistent in our principles. Thank you, Honorable Speaker.
I think we've debated, not enough, but I think some issues have come up that the Attorney General probably has a proposal. Let's listen to the proposal and see if we are agreeable or if it has captured what we were looking for, and then we move forward. Yes, Honorable.
Thank you, Madam Speaker. Madam Speaker, my legal draftsperson has come up with a proposal that I believe gives us a solution. And if I can just read it aloud, I agree with it, and I think it takes care of the concerns of the members here. And the proposal is this: a person shall be qualified to be appointed as a judge of the High Court if he or she has qualified to practice as a legal practitioner and has practiced law or has been a magistrate in a common law jurisdiction for not less than 5 years. I think that is the concern that the members have.
We are all agreeable from what I, yes, I've captured it. Yes. Sorry, we just want to make sure, if you can repeat it so that we'll capture it and it will be reflected in the final draft before the third reading. It will be printed. It will be printed.
A person shall be qualified to be appointed as a judge of the High Court if he or she has qualified to practice as a legal practitioner and has practiced law or has been a magistrate in a common law jurisdiction for not less than 5 years.
Yes, are we comfortable with that? Yes, thank you very much. Thank you very much. Okay.
Yes. Amendment of Section 139.
Yes, it is proposed that Clause 3, amendment of Section 139, stand part of the, as amended. The amendment as amended. It was an amended, it was an amendment, but it has been further amended. So as amended, stand part of the bill, as read by the Honorable Attorney General. Those in favor, please say aye. Aye. Those not in favor, please say no.
We vote for the amendment.
Pardon?
We need to vote for the amendment first, the amendment of the amendment.
Yeah, that's why I said as amended.
Yes, okay.
Yes, in fact, I did say as amended. That was when he raised his hand. I said it was initially, this is an amendment, but the amendment was further amended. And that's why I said as amended. So I can read it again. It is proposed that, that Clause 3, amendment of Section 139, stand part of the bill as amended.
Madam Speaker, I believe it's 139.4.
139.4, yes.
No, if you look at what we are putting in this clause.
You look at Clause 3.
Chair.
Sorry, let's not confuse each other. It's 3.
Chair.
Clause 3 is seeking to amend.
Subsection 4.
Can you see it? Yes. Thank you. Yeah. So we are together. Are we? Thank you very much. Now, Clause 3, as amended, stand part of the bill. Yes. It's clause 3. If you look at your document, it's amendment of section 139. That is clause 3. And then you have it's 139 subsection 3. I mean 4. I think I can read constitutions at least. Thank you.
Yeah, the confusion here, when we are in the process of amendment, we are concentrating on clause 4, not clause 3. So now if the amendment come on the floor, that's why we are confused.
Okay.
Because during the process we are dealing with 4.
The clarification from, no, it's all right.
No, what you're saying is subsection 4.
No, please, can I
Subsection 4.
Non-honorable, please, can I he's raised a point. I think it's for the chair or the mover to clarify, or the members of the committee, for them to clarify. Dealing with the bill, and the bill is an act to amend the Constitution of the Republic of the Gambia. Now the amendments are clauses 1, which is the title, clause 2, which is the amendment, clause 3, amendment of section 139, subclause 4. Yes, so it is flow. We are not amending, but it is clause 3 under the document that is being amended. Yes. So I think we're speaking the same language. Yes. Thank you. Honorable members will observe on the front page of the bill that the title reads, "This act may be cited as the Constitution of the Republic of the Gambia 1997 Amendment Act 2019." So we feel that it should read 2020. It's clear? Okay, so as amended, clause 1 as amended, stand part of the bill. Thank you very much. Yeah, let me just make this, please, Honorable Cantora. Can we? Yeah, the Assembly Business Committee has scheduled the 3rd reading of this bill, which will incorporate the new amendment for Monday, the 6th of July, 2020, as per the agenda that was circulated. You will see that in your agenda. Before this date, the Attorney General's Office and the Office of the Clerk, in accordance with Standing Order Clause 7220, would print again the amended version of the bill, including all the amendments will be incorporated therein for circulation to members before the 3rd reading. So we now move on to the next bill.
National Human Rights Commission Amendment Bill.
Honorable Chair.
Sorry, yeah, sorry.
Vote. Did we vote? We said aye and no.
Now, it is proposed that the bill entitled "An Act to Amend the Constitution of the Republic of the Gambia, Amendment Act 2020, as amended, stand part of the bill." That's all the clauses. Those in favor, please say aye. Those not in favor, say no. So the ayes have it. So the clauses as amended stand part of the bill. Thank you. We'll proceed with the next bill. Clerk?
Yes. National Human Rights Commission Amendment Bill 2020. Short title, Clause 1, short title.
It is proposed that Clause 1, short title of the bill, stand part of the bill. Those in favor? Pardon?
We did what?
The correct word? It is proposed that Clause 1, titled, sorry, the short title and the National Human Rights Commission Amendment Bill 2020 stand part of the bill. That's the short title, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. Yes. The amendment should also include the 2020 and not 2019. Yes, to Cantora.
What is the recommendation of the committee? Okay.
He's asking the recommendation of the committee. That's the substantive.
Yes, we're dealing with the short title. We'll come to the substance. Those in favor, please say aye. Those not in favor, please say no. So the clause 1, the short title, stands part of the bill. Thank you. Clerk, sir.
Clause 2, Amendment of the National Human Rights Commission Act 2017.
Thank you very much. It is proposed that Clause 2, Amendment of the National Human Rights Committee Act 2017, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. You can also refer to the report of the committee, as everybody has a copy. This appears to be my copy. Yeah, that's my copy. Thank you. There's an extra copy here.
Clause 3, Amendment of Section 2.
Thank you very much. It is proposed that Clause 3, Amendment of Section 2, stand part of the bill. Those in favor, please say aye. Yes, Cantora. Section 2 of the Principal Act is amended by inserting the following definitions in alphabetical order. Commission, Secretariat, Staff. Yes, Serekunda.
Yeah, I'm just asking, the Secretariat, it means the administrative body of the Commission. I don't know whether the Honorable Attorney General will look at this. Is it administrative body or the administrative headquarters? Either is administrative headquarters. I'm just asking. It said the administrative body of the Commission. That's the Secretariat. Is that appropriate? If it is okay, it's all right. If it is headquarters, it's okay. All right, let's go ahead. It's okay with them then.
Any more issues on Clause 3? Okay, we proceed, Clerk.
We read it. Clause 4, Amendment of Section.
Let me read it. Yes, Clause 3. Clause 3, Amendment of Section 2 of the Act, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. It now stands part of the bill. Yes, clause 3 now. Oh, you didn't hear me. I said.
The declaration.
Oh, you didn't hear me. Sorry. I said clause 3 now stands part of the bill.
Thank you.
Sorry, I have this.
Clause 4, amendment of section 6.
Thank you. It is proposed that clause 4, amendment of section 6, stand part of the bill. Those in favor? No. Any issues? Yes, please.
Yes, Honorable Speaker, what we have said was it's like they want to increase the term instead of, say, from 4 years to 5 years. That's the issue that was here. 3 to 4. A member of the commission shall hold office for 3 years and is eligible for reappointment for further term. One further term. Yeah, I think that's the original. Yes, and then here we are saying the chairperson of the commission shall hold office for 5 years, and the other commissioners shall hold office for 4 years, and both shall be eligible for reappointment. Yeah, one further term for reappointment. That's what is in the Act. Yes. Yes, and that's what the commission was asking.
So what is the issue?
No, there is an issue. This one is saying the chairperson of the commission shall hold office for 5 years, and the other commissioners shall hold office for 4 years. That's the difference.
On page 1, clause 4, amendment of section 6. You want to compare it to the proposed amendment in the report? See whether
Even the report agrees.
I think it's the same. You can read it and see. No, let him satisfy himself, Honorable. Let's allow him to. Honorable, let me just help you. I think the confusion is we reproduced the amendment, and that we reproduced the original, and that is the one talking about 3 years.
The original is 3 years.
Yes, the original is 3
yes,
years.
But now
that is but that is what the committee has reproduced. Now then you come to the proposal,
yes,
which is now 4 years, agreeing with what is.
Yeah.
You agree? Okay, good. Now we move over to Upper Fuladu.
Yes, the words for one further term is missing in my amendment. Eligible for reappointment for one further term is missing in the recommendations that I have by the committee. No, 2017.
Make sure that all these things are incorporated for the final copies out. Yes. Thank you. Yes, Serakunda.
Yeah, I think, Honorable Chair, if we concentrate on the text of the amendment and then use our report just for reference purposes. So the text of the amendment is that the chairperson of the commission shall hold office for 5 years, and the other commissioners shall hold office for 4 years, and they are both eligible for appointment for one further term. That is what we are to consider. Is there any opinion that is different from this that we need to consider? So if there is none, then we should just proceed. This is the amendment proposed.
No other opinion. I think he's just drawing the fact that a few words are missing in the report, which the chair will take into consideration. Thank you. So can we move? Thank you. Let's put the question. It's here for no, there's no amendment on clause 4. Clause 4 stand part of the bill. No, we had already made the proposal, didn't we?
Interrupted by debate.
Oh, we were telling me that we were interrupted by the debate. Okay, then it is proposed that clause 4, amendment of section 6, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So the clause 4, amendment of section 6, now stand part of the bill. Thank you. We move.
Yes. Clause 5, amendment of section 9.
Okay. Thank you. It is proposed that clause 5, amendment of section 9, stand part of the bill. Any issues? Yes, Serekunda. Banjul South.
Does it stand based on the recommendations of the committee? Because the committee recommended that amendment, we did not approve that amendment. So does that still stand? Section 9, because you said as amended. Are we amending?
Open to debate. That's what we are debating.
Yeah, because
but you can
the
refer
committee,
to your...
what the committee recommended, after the consideration, the committee recommended that we go ahead with the bill with the exception of the proposed amendment of section 9. Yeah.
Yes, taking that into consideration. Yes, Wooly is?
I'm saying we did not change anything there. We maintain it. Yes, it's maintained. And they have agreed that it should be maintained as it was. Yeah. I
want to be with you as well. The agreement, is it, or the debate is for or, in quotes, or from any other cause be deleted or be maintained? Be maintained.
No, they are confusing. What are you saying?
So that we do the correct thing. Now look at your, I have a copy of the Parent Act, section 9. Section 9, 1A, inability to perform the functions of his or her office arising from infirmity of mind or body or from any other cause. Now, the amendment to the bill here is saying that Section 9 of the Principal Act, which I have just read, that is subsection 1A, by deleting the words from any other cause. So, I want to hear the debate, yes. Kandora?
Yeah, the committee, they are recommending that it should stay, but the proposed amendment to the bill by the ministry is to delete. Yes, but they are requesting it to stay.
It's of the view that it should stay. Let's get the...
No.
Banjul Sir? No? Okay, Serekunda.
Honorable Speaker, it seems like the mover then will be more progressive than the Assembly. What is subject to abuse is from any other cause. That is the sky. So, this is where we had problems with the Independent Electoral Commission, where President will just come and remove you, say, on what basis? And then you will have no basis from any other cause like anything. We should certainly support this progressive amendment and cause the deletion of this particular clause. We can be subject to abuse.
Honorable Speaker, we made a report here regarding this. And what we have said is that this is not standing in isolation. It is connected to the phrase, infirmity of body or mind. So any other cause must be related to this phrase. It cannot be outside of this phrase. And that is the recommendation we have made here. And even went further to show the root of the phrase. Yes. There is no confusion there.
I allow you to come in, but let's take more interventions. Central Badibu.
Honorable Speaker, I also agree with the Honorable Member of Serekunda, because as is explained by the Chair, we cannot see the connection, what he is saying now, to this any other cause. So any other cause, I also am with the opinion that should be deleted.
Yeah, I am buying this same idea of Serekunda because of the fact that anything that is vague could be interpreted in any way by the actor himself. If the president would have to remove a particular judge without even considering the infirmity of body or mind, because there is that small excuse there, it could be interpreted in his own way. Let's be specific.
Thank you. Thank you, Honorable Chair. I think I'm just trying to emphasize what have been said by the previous speakers, because we're trying to avoid a situation where the individual will use certain grievances because of the powers vested on you to act in a manner that is not going to suit the interests of the nation. So I think we need to better qualify that statement.
It is qualified.
Okay, Madam Speaker, let me just refer the Parliament to the report of the committee. Can we go there? Page 4. The National Human Rights Commission was explaining this, and they explained that the purpose of suggesting the amendment was to prevent or deter the executive from abusing the phrase. But the committee directed the attention of the Human Rights Commission to the statutory rules of the interpretation. Sui generis, that means from any other cause, will be interpreted in line with the infirmity of mind or body. Thus, it is not capable of being misused, and even in such a case, the National Human Rights Commission Act demands a medical board to sit and investigate the matter before any commissioner is removed. I think that should help us.
Please.
I think I'm okay. I wanted to elaborate because on that day I remember fully this is what we were discussing and we were all there. So I don't think it needs any debate. I think we should carry on.
Thank you very much, Honorable Chair. Well, I think what the Honorable Member for Sabah Sanjal explained indicates that there is no connection. This can be subjected to abuse.
No, it's not.
No, I'm coming. Honorable, I'm on my... I'm just urging the members of the committee to really concede that definitely this is giving room for abuse. Any other cause can be anything. We just are urging you to concede that this one definitely is not a progressive amendment. Thank you.
Take Upper Fuladu so that I'll allow the Honorable AG to respond.
Yes, given the fact that this provision has exhausted reasons for removal, I think the phrase from any other cause is opening it up again, because it's talked about incompetence, bankruptcy, convictions, and other issues. So it has exhausted the reasons, but from any other cause, basically here is prone to abuse. I think it should be removed now to make sure these things are clarified.
That phrase should be deleted. Kantora, please.
Thank you, Honorable Speaker. I think the bone of contention is the context of this particular phrase, where it's connected to the body and mind. So it is within those confines that if anything goes contrary, it has to be connected to that particular context. So you cannot do it outside a context. You've been guided here that from any other cause has to be in this context. And also, issue of abuse also, you can't do it unilaterally. There's a commission put in place. If you accuse somebody for issue of mentally sound or whatever you call it, it has to be investigated. So this is connecting with this particular provision that is not used in anywhere, but in this context it has to be applied. But I don't know what is the legal interpretation of this with the lawyers. Thank you.
We have so many lawyers down here. Lower Nyomi.
Madam Speaker, to ease us all, why can't we just omit from any other cause rather than linking it up? Tomorrow, when the guy is acting, we would not be there for interpretation. But he would have acted according to what we have agreed on, what we have provided, what we think would not be any ambiguity. But here, it is vague. It is vague. I can seize it and act on it in any way.
Yes, Joshua.
I think we don't have a big problem. The ones that are proposing that we leave it as it is to include any other cause, I would just ask, what would that be after exhausting all that list? In connection to body, infirmity of body and mind, what would that any other cause be? It's bringing more confusion than any other thing. So why don't we just delete it?
Honorable Deputy Speaker.
Madam Speaker, Madam Chair. Madam Chair, I think this is the beauty of democracy, and the members has raised their concern over this issue. I would suggest that if this matter can be referred to the Attorney General so that I can make some clarity. Thank you.
I think we have to progress. Let's allow Wuli Issus, the chair of the committee, and then the Attorney General. I think we've had many views. For me, I'm now clear, so then we thank you. Yes?
Okay, thank you. When we were discussing this, we were all with the mind to remove any other cause from it. We are agreeing with the Commission because when they brought their reason, we thought it was okay. But when we went through the legal interpretation by our legal minds, it is explained that these things are connected. Any other cause is within the confines of those things that he was mentioning. So if it is bringing confusion, I can imagine if all these people are confused by it, then the actor may also be confused, even though I don't agree with it, but then we can delete that. I will concede that we consider deleting it.
I think you should first of all consult with your community members and try to convince them so that you concede. It is an honor to concede. We all concede. So. Honorable Attorney General. Yes, sir.
Madam Chair, I agree with the Honorable Member Serekunda that the state appears to want to be more progressive than some members of the Assembly. We want to remove any other cause. The any other cause is not linked to the infirmity of body or mind. It is linked to the inability to perform. And we have, under the different subparagraphs, other conditions that may lead to removal. And that is why we thought the any other cause is not only redundant, but it's also is potential for abuse. And since we're trying to strengthen these institutions, we thought we agreed with the National Human Rights Commission in our consultation with them to delete. It is now up to this House to agree with us or to do otherwise. Thank you.
I think it appears that the House has agreed to get that clause deleted. So the amendment will now stand. The amendment will now stand. So clause 5, amendment of section 9, stand part of the bill. It is proposed. Yes, it is proposed. Stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. Now, clause 5, amendment of section 9, now stands part of the bill. Thank you. Clerk,
clause 6, amendment of section 11.
Thank you. It is proposed that clause 6, amendment of section 11, stand part of the bill. Sorry. Those in favor? No, 11 what? It's amended. It's amendment of section 11. Section 11 of the Principal Act is amended by deleting subsection 2 and substituting it for the following. So, I mean, I think we're in order. Thank you. So it is proposed that clause 6, amendment of section 11, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. So now clause 6, amendment of section 11, now stand part of the bill. Thank you. Clerk, can we proceed?
Clause 7, amendment of section 15.
Thank you. It is proposed that clause 7, amendment of section 15, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. Clause 7, amendment of section 15, now stand part of the bill. You proceed to the next one.
Clause 8, amendment of section 26.
Thank you. It is proposed that clause 8, amendment of section 26, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. Now clause 8, amendment of section 26, now stands part of the bill. Thank you.
Clause 9, amendment of section 27(1)(b).
Thank you very much. It is proposed that clause 9, amendment of section 27(1)(b), stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. So clause 9, amendment of section 27(1)(b), now stand part of the bill. Honorable members, the Assembly Business Committee has also scheduled the third reading of the bill for Monday, the 6th of July, 2020. Before this date, the Attorney General's Office and the Office of the Clerk, in accordance with Standing Order Clause 7220, would print again the amended version, including the amendments, for circulation to honorable members before the third reading, that is before the 6th of July. Yes. Thank you. The Assembly now resumes. Honorable members, the Assembly now resumes. Before we continue with the next business on the agenda, which had been communicated earlier on, and that is the consideration stage for the, sorry, that's the second reading. That's the next business is the third reading of the, no, it's not, it's the second reading.
No, what I'm saying.
Okay. Now, as I said, the Assembly now resumes. And as communicated earlier at the consideration stage, the third reading for the bills, that is the Constitution Amendment Bill 2020 and the National Human Rights Bill 2020 are now scheduled for Monday, the 6th of July, 2020, for the Honorable Attorney General to move for their third reading. However, before that date, the Attorney General's office is hereby urged to comply with Standing Order 7220 to ensure that the amended versions of the bills are all printed and circulated to honorable members in advance. I thank you all for your kind attention, but as I said, before we proceed with the next business of the House on today's order paper, which is the second reading of the Public Service Commission Bill 2020 by His Excellency the Vice President, I would wish to take the opportunity to inform honorable members, I am sure they are aware of, that the Honorable Attorney General is leaving us, and today will be his last appearance before this Assembly. And honorable members will agree with me that I think he's been the most consultative. We've had more engagements with the Honorable Attorney General during this 5th legislature than any other honorable minister, except for finance, is it Minister of Finance. Honorable Attorney General, well, we had wished that you would stay and complete the businesses that we have started together, especially the bills that have been tabled. But of course, I am sure wherever you are, you will have Gambia at the back of your mind. And we wish you all the best in your next endeavor. And we hope and pray to continue working with your successor in like manner. On that note, I thank you very much on behalf of all honorable members and also staff of the Assembly. Just a second. And just want to appeal to honorable ministers for me to use my discretion to allow the honorable minister, Attorney General and Minister for Justice, to make a short statement. Thank you, honorable.
Speaker widely said, today hopefully is my last appearance before you after 3.5 years together. I guess parting is never easy. And I have had some memorable encounters with almost all of you. It's not been easy at times. Some have actually recently threatened to conduct citizens' arrest on me. Others have labeled me incompetent. But that is the joy of democracy. It is the joy of what each and every one of us here in this assembly fought for many, many years. Many of you devoted your entire lives to fighting this cause. And on a day like today, I would like to single out the honorable member for Serekunda for his devotion to fighting for this freedom for many, many years. I recall when I was a student at St. Augustine's and we used to be excited with socialist Marxist ideas, and we would invite him to come and give talks at our symposium. He wouldn't remember that, but I would as a student, and I used to be inspired by him. It's been 3.5 short and long years. It's been difficult sometimes, but I only wish to remind all the members here that our country is at a crossroads. You are all patriotic men and women of this country. You represent our people here. Everything you say, everything you do on behalf of the people of this country. And I know that. But the responsibility to traverse from this very shaky water to a more stable and institutionalized democracy rests on each and every one of us. And we cannot do that without peace. It is what we have, it's our national treasure. It is what we must always preserve. Peace and stability. I would like to take this opportunity to thank each and every one of you for the engagement, for your criticisms, for your compliments, and for the openness. The Gambia has changed. It will only change for the better from now on. You, more than anyone out there, has a unique responsibility to ensure that there is transparent, open, and accountable government in this country. You, more than any other constituency out there, have a unique ability to check the excesses of power. You have a heavy burden to make sure that this country will no longer go back to a dictatorship. And you are already doing that. I can only encourage you to do that some more. See the executive as your partners in development and engage constructively. Of course, sometimes our decisions will be swayed by our partisan political interests. But what makes us true Democrats is the ability to identify a national crisis and come together and put aside our political differences. It's going to be difficult going forward. Democracy is chaos. We will not like some of the things that have been said about us. We will not like the insults on social media. We will not like the unfair, unjustified criticism sometimes. But I personally, and I know as much as you, prefer to live in this climate than the climate that we came from on 1st of December 2016. It belongs, or it behoves all of us to ensure that the Gambia we bequeath to future generations is the Gambia that we inherited before 22nd July 1994. I thank you all for your support. I thank you, Honorable Speaker. I thank the Office of Clerk. I thank you.
Very much, Honorable PG, for those kind words. I would allow, again, I'm using my discretion, 2 or 3 honorable members who may wish to say something. Otherwise, yes, we'll take one from honorable member for Lower Nyomi. Yes, okay. Yes, thank you. We'll take these 3. Thank you.
Honorable members, Madam Speaker, today is a sad day. It's also a very happy day. This is the embodiment of parting. It is sweet, but it is also bitter. To him who is going, is sweet to him. But to us, whom he has left behind, or whom he is leaving behind, is painful. Because we have been used to him. He is talked of 3.5 years. He did not talk of 3.5 days. He did not talk of 3.5 months. He talked of 3.5 years. I remember meeting this minister, if you could recall, when the trees were being planted on the frontage. That was the first time I met him in the flesh. I had wanted to discuss certain things with him. I asked for his telephone number. This man is a very committed man. He is very sincere and he is very honest. The last time I requested information from him was about 2 weeks back, when I was receiving the mayor or the mayoress of Banjul to clarify why I should be given 10 people, considering the fact that I have that high-profile personality coming to the constituency for the extension of a donation. He said it as it should be. I acted as I thought I would be. But we are losing. We are losing. I hope the guy who is going to take after you would be able to stand on the same stead and be very open, be very honest, be very dedicated, and be very sincere. Not only to the office and to the man who appointed him, but to the nation. Because that's the whole barometer. Honorable Minister, thank you for your time. Thank you for your dedication. Thank you for your support. And thank you for the work that you have done for this nation. We can attest to that. Those of us who have had this interaction with you, thank you very much.
Thank you. Banjul South. emphasize.
Thank you very much, Madam Speaker. It's an emotional day having to say goodbye to Bar. For me, it's not goodbye. It's see you later. Because Bar is not, I've known Bar for a long time. It's not only work. He's a friend. He's also a brother. You can all attest, and Bar can attest, that I detach emotions from my work. I think I've been one of the hardest on Bar in this National Assembly. Not because I question his integrity, but I know Bar can take us where we wanted to go. That was why I kept pushing. I stopped having breakfast with Bar at his place because of work, because I wanted to detach our personal and professional work. But Bar, I wish you well. I know that where you are going, you will continue serving us, and we're looking up to you to continue serving us. All I can say today is thank you for your services to this nation. You came in when it was needed. You've been criticized. You've heard so many things, but I wish those people saying that have done a bit of what you have done. Thank you.
Honorable Member Serekunda.
Thank you very much, Honorable Speaker. When one is singled out, one is also weakened to make comments. But it is duty-bound to do so. Having lived this long and being associated with so many things, I have to use every occasion to share lessons. Honorable Speaker, justice and mercy are two sides of a coin. And we've heard the Attorney General. Today, Attorney General, tomorrow, ex-Attorney General. And that's the same for all of us. What legacy do we leave behind? Is really what matters. And essentially, jobs have to be done. And one thing that we must learn is to separate work to be done and the person doing it. When we are here, we must abide by the dictates of the Constitution, of conscience, of the national interest. We must separate our individual selves from the national cause, the national duty. What is important at this stage is to examine the tasks that confronted the nation and those who had to carry out responsibility to ensure that the nation move forward. Mistakes are unavoidable. Personal conflicts are unavoidable. But ultimately, we must move on and the nation must move on. And we hope today, as he leaves this forum, he will go knowing that this is Gambia, this is homeland, and each of us belongs to this nation. And it is our duty to want to build a nation that we will want our children and our children's children to inherit and be proud of. So in the spirit of national unity, we hope this departure will touch the heart of every member of this parliament, so that we see a person who has had a job to do and had to face us, and we also had a job to do and had to confront him under certain circumstances, so that ultimately we achieve a purpose worth achieving. And as we go our separate ways, we go with the spirit of forgiveness, spirit of real national reconciliation, to know that after justice then there must be peace, and we must move forward with reconciliation before there is that peace. Every starting point requires a new spirit. It will not be nice after a conflict, because you must settle all that existed during the period. But after all that, we should have a new beginning. And I hope that he will have a new beginning where he is going, and we will continue to search for that new beginning of a Gambia that all of us will belong to, and all of us will wish to serve. All of us will give our mind and heart so that we shape a destiny where there will be no conflict that we see today, no hatred that we may see today, but that all of us will know that we have a job to do for the nation and for the best of all of us. We wish him the best, and we hope that he leaves the Gambia knowing that this parliament is striving as much as possible to at least bring that new ethos of building a country for all of us. Thank you very much.
Yes, lastly, Honorable Member for Central Badibu, but not the least.
Thank you, Honorable Speaker. Honorable Speaker, today is a day of moment. It's historic in the history of Gambia. The Honorable Minister is a man of dignity. He's a man who has the country in heart, a man who has served for the purpose. Madam Speaker, I think this is a lesson for all of us to learn how to become patriotic. It's not only by word of mouth, it's by action. And he has lived beyond all reasonable doubt that he's a true son of Gambia. I believe he is going to serve Africans wherever he is going. He will serve us and the continent at large. But I believe the journey that we have started, the journey must be accomplished. And I believe sooner or later, you will join us to ensure that we reach to the promised land. Madam Speaker, we must have one aim and one destiny. That is how to transform this country, how to make Gambia a beacon of Africa. And I believe members of Parliament and the executive can do it. Our relationship with Ba was cordial, was more of development than political. He was a man who was very neutral in his job. He was very neutral and he was very accommodative. Madam Speaker, I will miss him for the morning jokes that we used to have, our traditional jokes that enrichen our culture, Mandinka and Sarahule. I will miss that one. But I will pray for him so that he can come back. We continue the mission, as I said, luta continua. Thank you, Honorable Minister.
Thank you very much, Honorable AG, and we wish you all the best, as has already been alluded to. So, honorable members, we still have some.
Madam Speaker, press. Press already, press.
Few seconds so that we'll proceed with the next item on the order paper, and that's the third reading. Sorry, the second reading of the pensions. Let's allow Her Excellency the Vice President to settle down and Can we proceed with the next item?
Bill, in reference to Standing Order 66, second reading, Public Service Pension Bill 2020 by Her Excellency the Vice President.
Thank you very much. Good afternoon. Your Excellency the Vice President, welcome back to the National Assembly. Honorable members will recall that the first reading of the Public Service Pensions Bill 2020 was tabled on Wednesday, the 24th of June, 2020, and today was appointed for the second reading in accordance with Standing Order 66-2. Pursuant to Clause 67 of the Standing Orders, Her Excellency the Vice President now move a motion for the second reading of the bill entitled the Public Service Pensions Bill 2020. If the motion is carried, the clerk will read aloud the short title of the bill and shall declare it to have been read a second time. Thereafter, the Assembly may debate on the general merits and principles of the bill as per the Standing Order, specifically Clause 67(1), after which the bill shall stand referred to the Assembly Business Committee for committal. This is in accordance with Standing Order 68(1). I'll now invite Her Excellency the Vice President to move the motion. Your Excellency, thank you.
Good morning, Honorable Speaker. I beg to move that a bill entitled Public Service Pensions Bill 2020 be read a second time. Honorable Speaker, the current pensions bill, which was enacted in 1950, contains many references and provisions that are no longer applicable to the Gambia of today. Besides, the benefits provided by the scheme at retirement are very low. In fact, the benefits are generally too low to maintain a reasonable standard of living for the retirees. The main reason for the low government pension is, among others, low pay, since the take-home pay of civil servants used to calculate pension benefits include several tax-free allowances, which are not included in the base for the computation of pension benefits. To address the shortcomings, a pension actuarial study was carried out in 2013. The study recommended that the Pension Act 1950 be reviewed and the current non-contributory pension scheme be replaced by a contributory scheme. As part of the Civil Service Reform Program, the World Bank provided support to the government of the Gambia to undertake a review and development of a new pension act. To this effect, a consultant was recruited and developed a draft pension bill which was validated by all stakeholders. Honorable Speaker, the effect of the Public Service Pension Bill is that the Pension Act 1950 will be repealed and several new provisions be introduced. The key new features of the new Pensions Bill with the 1950 Act does not provide are as follows. Retirement benefits to be paid within 30 days. Benefits have been enhanced because of the following. Gross salary will be the basis for computing benefits. The accrual rate has been standardized and thus benefiting lower cadre of staff. Introduction of minimum pension and enhanced maximum pension and automatic pension increase after 4 years. Pension has been made actuarially fair for all retirees. The refund of contributions with interest to those who are ineligible for pension enhances the quality of life for those exiting from service. Dependent pension for 5 years have been introduced to enhance the quality of life of dependents of a deceased pensioner or officer in service. Pension for those living on account of incapacity has been provided for. Those resigning from service under the Pension Act 1950 were ineligible for any benefit. But under the new pension bill, their benefits will be preserved until they attain the voluntary early retirement age. In case of a missing member, a presumption of death will be made and death benefits to dependents will be paid. Accrued pension is a right under the new legislation. For pensioners who are imprisoned, bankrupt or insolvent, their pensions will not cease but will be paid to nominated beneficiaries until their status is reversed. And administration and management of the scheme will be centralized. Honorable Speaker, the scheme will be funded by government and contributions deducted from individual civil servants as stipulated below. Pensions, gratuities, and any other benefit which are payable under this Act shall be funded by the government tax revenues and contributions made by public officers employed by the government. The Accountant General shall deduct contributions from every public officer an amount equivalent to 5% of pensionable emoluments, and the amount shall be remitted immediately to the consolidated fund. The government shall meet the balance of the cost of the pension gratuity or other benefits payable under this Act after allowing for contributions referred to above. Honorable Speaker, it is indeed important to point out that the proposed pension scheme is a defined benefit scheme as opposed to a defined contribution scheme. The scheme sets out the specific benefits to be availed to the retiree as highlighted above. As such, upon attaining the age of retirement, a civil servant's pension is calculated taking into consideration average salary and length of service to determine the amount payable to the retiree. If the amount is more than the 5% the civil servant has been contributing, which is very much likely, government will pay for the balance as indicated on point C above. The 5% civil servant's contribution is estimated to generate over 173.6 billion Gambian dollars yearly, which will be directly and immediately remitted to consolidated revenue fund. This figure is based on the current staff complement of the civil service. Honorable Speaker, the new pensions bill seeks to repeal the 1950 Pensions Act, hence the involvement of the Office of the Solicitor General from inception of the review to date. The Solicitor General participated in the development and finalization of the terms of reference for the consultancy and further participated in the recruitment and selection of the consultant. Once recruited, the consultant worked with the Office of the Solicitor General throughout the review process. Similarly, following the completion of the review, the consultant produced a draft pension bill which was subjected to an in-house review attended by key stakeholders, including the Solicitor General before the wider stakeholder validation workshop. Furthermore, upon validation, the draft bill was submitted to the Solicitor General for legal formatting and subsequent gazetting after approval by the Cabinet. Honorable Speaker, there are general provisions on the management of the transition period once the bill is enacted. This is important because the bill proposes to repeal the Pensions Act 1950, which has been in force since 1946 and under which current pensioners receive their pensions. This part repeals the Pensions Act 1950 and provides that current pensioners will continue to receive their pensions under that repealed act. It also provides for the calculation of benefits during the transition period for those officers still in service to ensure fairness. If there are pending proceedings, whether criminal or civil, under the Pensions Act, they will proceed to be prosecuted under that statute. Other laws or subsidiary legislations which are currently in force relating to pensions are preserved by the bill until those laws are repealed or revoked. The Minister will make more regulations under the bill to ensure that the bill, once enacted, is better carried out in the course of implementation. Honorable Speaker, to minimize the undue delay in the processing of pension benefits, there will be centralized Directorate of Pensions under PMO charged with the responsibility of administration and management of pension benefits. This will expedite the payment process and reduce the physical movement of personnel files from one department to the other as being practiced currently. The Directorate will be headed by a director and shall have 4 core business units, namely registration management, assessment and verification, account management and operations, which shall manage registration, assess and verify benefit computation, and manage accounts. There will be other support functions, such as IT services, risk management, operations, policy, complaints management, and communication. Honorable Speaker, with this introductory statement, I beg to move. Thank you very much.
Thank you very much. Any seconder? Yeah, Kiang East. Yes, thank you.
Thank you, Honorable Speaker. I rise to second the motion, and I would like to use this opportunity to make a very short intervention. Honorable Speaker, this bill is not only timely, but it is welcome. Anyone who is familiar with these pension issues will understand that retired civil servants at the end of their service receive very, very little pension to enable them to live a good life. Pensions are extremely low. This is because, according to the Honorable Vice President's statement, salaries are very, very low, and therefore the pensions that are generated through or from these salaries are equally low, resulting to very, very low pensions and poor condition of living, especially for those civil servants who have retired and have not got very good support from family members. So this is why I said this is very timely. And Honorable Speaker.
Point of order, ma'am. I'm raising
Order?
Yes, I'm raising a point of order.
Which order?
Clause 64 of the standing order. Objects and reasons of memorandum to be accompanied by the bill. And if you go to the last page, I think it's omitted. Is it by drafting error or what? Thank you.
It's observed. I've just looked at it, but if you say order when he's on his left, I don't think that has anything to do with him. So, yes, please, thank you. Let's allow him to continue.
Honorable Speaker, Honorable Speaker, may I continue, please? Oh, she's busy talking to somebody. All right, okay, Honorable Speaker, not only are these pensions very, very low, but they are extremely difficult to get. I have known people who have retired from the civil service, and they have expended a great deal of effort to try to get these pensions because one, they are centralized, and two, because of want of proper record keeping. Records regarding these civil servants were not properly kept, and sometimes it was very, very difficult for them to get access to these records so as to get their pensions on time. So I hope that this new bill will seek to address all those issues, because otherwise the purpose will be defeated. Honorable Speaker, I have seen personal accounts of people who have retired from the civil service. They have tried and tried until they died without having access to their benefits after retiring from the civil service. And this is why in the beginning I said it's very, very timely, and it is also a welcoming move to come up with such a bill. But since the bill is going to be committed to the relevant committee, and thereafter the report to be brought back, I will reserve some of my comments until the report is brought back here for scrutiny and probably debate. On that note, thank you, Honorable Speaker.
Yes, thank you very much. Honorable members, it has been moved and seconded that the bill entitled the Public Service Pensions Bill 2020 be read a second time. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. Clerk, can you read the short title of the bill?
Bill, Public Service Pension Bill 2020.
Thank you. In accordance with clause 67(1) of the standing orders, I'll now open the floor for debate on the general merits and principles of the bill. So honorable members who wish to take part in the debate may do so by raising their constituency tags. I've already had some on my list, so I'll start with Birkama South. But please continue raising your tags so that... Yes.
Honorable motion, please. Yes. If you look at the Constitution 1012, no bills other than the bill referred to this subject have been introduced to the National Assembly unless accompanied by memorandum and other object of the bill. And this is absent in the bill. So I would have preferred it for them to capture that observation, the reasons and objects before debating. It's not provided under the current bill to send it back again.
I think it's an issue, and there's a motion on the floor, so any secondment? Yes, Woolly East.
Yes, Honorable Speaker, thank you very much. I rise to second the motion that the bill be returned until it is the objects and reasons are captured in the bill before it is introduced. Thank you.
Thank you. A motion has been moved and seconded that the bill be withdrawn and the reasons and objects be included, and the debate will resume after the inclusion of the reasons and objects of the bill. Those in favor of the motion, please say aye.
Aye.
Those not in favor, please say no. So the debate is now suspended until the reasons and objects of the bill are included. Thank you. Sorry, that brings us to the end of today's sittings. Now, in consultation with the Assembly Business Committee, certain government businesses have been included in the business of the Assembly for this session, which we are not originally in. And one of them is there's a motion to be tabled for the extension of a state of public emergency. And the motion will be tabled tomorrow. And the table office, together with the office of the clerk, will endeavor to make the documents available for your scrutiny prior to that. And on that note, I will now put the question: be it resolved that this August Assembly do stand adjourned till Tuesday, the 30th of June, 2020 at 10 a.m. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. The Assembly now stands adjourned till Tuesday, the 30th of June, 2020 at 10 a.m. prompt. Thank you.